was interesting to sit through in that she was scared to death going into it because she's never been deposed before. But the tactics they used were just appalling to me. For instance, they were very intimidating to her, and very much as they presented them in a most gentlemanly manner, they were also fear tactics. And they started back with questions. Now here's an 85-year-old woman, and they started with, you know, what did you do in high school? What's your education? Did you go any further than high school? You know, did you marry any men back at that time? You didn't get married until your 40s. So they took her through every, part of her life up until the time she married my uncle. And sitting back and watching it, and they have a right to do it, unfortunately, but it is what it is. They were just intimidating, in my opinion. They were just intimidating questions to let her know, if this goes to trial, here's the kind of questions we're going to ask you. And it scared her to death.
The surprise was we assumed we were going to get there in the morning of the trial, that they'd want to make a settlement offer, and we wouldn't put this 85-year-old woman through a trial. But we were surprised they came up with a new strategy that was unbeknownst to us, and they introduced it the morning of the trial out of the earshot of the jury. And that is a little-known arcane law in Missouri called sole cause. So sole, S-O-L-E. If there's a sole cause of an accident that really doesn't make it anybody's responsibility, and it just happened, then it may be someone's fault, but it's not their responsibility. They were there just for their economic purpose. What can we do? How do we get out of this? The things that were said at the trial, sitting through 4 days of a trial, listening to why they shouldn't have to pay anything, why it's not really their fault. And the Shea family's already taken care of her, talking to the jury. So, they're already taking care of her, so she really doesn't need that much. And then they had a second one. Well, yes, it was the vehicle of the business. It was the nephew of the owner who did work there, who was going to get produce for the business. Nobody ever disputed that. But he hadn't clocked in yet because his start time was 2 o'clock. The accident happened at 10 to 1 or whatever it was. Therefore, it's not that responsibility, so that insurance policy shouldn't even have to worry about it. And the judge again said, I'll rule on that later. You can't argue it to the jury, but he ruled before closing arguments.
We had a forensic engineer come in and recreate the accident based on all of the evidence. And the evidence started when the collision happened. OnStar in the boy's car immediately registered several things: the time of the accident, the force of the accident. So he took where the marks where the cars dug into the pavement and so forth, and he recreated what was really the forensic of the accident, and showed where the point of impact took place, how the cars repelled, what direction they went, and what the speed of each would have been, even though the speed was registered. Let me take that back. I'm not sure the speed was registered on OnStar, but the force was registered, and figured out what his speed was, which was just a little bit over the speed limit, not a lot. What my aunt's speed was, which was about 45 miles an hour, and showed by the way the cars moved away from each other and where they ended up, how all this worked. One of the lawyers wanted to argue that he couldn't possibly know that for sure, and had he used a different methodology, that the number would have been less. And the forensic engineer explained to the lawyer that, no, you're wrong. Had I used your methodology, I would have showed the boy's rate of speed higher. And the lawyer wanted to argue with him that he must be incorrect. The forensic engineer said, I'll do the math on a white paper here for the jury if you want me to show you why you're wrong. And he said, no, I don't want you to show me. So he did a good job of explaining just about everything you could know about the accident. In closing argument, one of the insurance company lawyers determined for argument to the jury that this is just hocus pocus. Nobody could possibly know what this is, so you essentially need to disregard anything this forensic engineer said. It was a very odd thing to listen to.
Well, that's a typical defense tactic. When you have the facts, you argue the facts. When you have the law, you argue the law. When you don't have either one, you pound the table. And it sounds like there was a lot of table pounding going on in the final argument. And that's not unusual. If you don't like the testimony of an expert, the insurance lawyers will call it junk science or hocus pocus and try to get the jury to ignore it or disregard it in some respect.
Catherine was a extremely vigorous, healthy, kind and sweet, and wonderful young for her age woman. She was an active gardener and that she walked a lot. She was healthy and vigorous and appeared younger or seemed younger, and to my examinations acted younger than her chronologic age.
She had testified, I just want as much independence as I can have. I don't want to feel like I've got to ask my family for everything I get. Can I have a ride to go here? Can I go shopping? Can I do this or that? And he said, well, she could get up and run some errands. She could drive a car. And we were all dumbfounded by that. And there's no way that this woman could drive a car because of her legs condition. There's just no possible way, but he determined for the jury that she could drive and run errands if she wanted to. They were there just for their economic purpose. What can we do? How do we get out of this? The things that were said at the trial, sitting it through 4 days of a trial, listening to why they shouldn't have to pay anything, why it's not really their fault. And the Shea family's already taken care of her, talking to the jury. So, they're already taking care of her, so she really doesn't need that much. Let's not overplay this. Let's not overblow this.